Good afternoon, everyone. Thank you for joining us today for our webinar series, Legal Planning for Specialty Crop Producers. My name is Chloe Marie. I am a research specialist at the Penn State Law Center for Agricultural and Shale Law, and I have a few housekeeping notes before we begin this webinar. So first, please note that this webinar is being recorded. All registrants will receive access to this recording, as well as recordings of the other presentations in our series. Check the bottom of the reminder email that you received from Zoom to find the link of the prior recordings. And you will also receive another email with the link to this recording once it is made available. And if you have any questions during this presentation, please put them in the Q&A and we will make sure to save some time at the end to answer them. And to get a copy of this PowerPoint, check out the event page on our website. And as we're getting started, I would like to provide a little background on the center's organization. Our director is Ross Pfeiffer, Jackie Schweckler, Audrey Thompson, and Brook Duer are our staff attorneys. And in a couple minutes, you will meet Brook Duer. So here at the center, we provide numerous resources for agricultural legal stakeholders through our website at aglo.psu.edu. If you would like to learn more about a specific topic in agricultural law, please check out our agricultural law virtual resource rooms and issue trackers. Our issue trackers are similar to our resource rooms, but provide more of a timeline of developments for a specific topic. And for more frequent updates, you can subscribe to the Agricultural Law Weekly Review. You will receive a once-a-week email with all the most important updates in agricultural law. But if you would rather listen than read, you can also subscribe to our Agricultural Law podcast. Our podcast can be found in all the usual podcast streaming platforms like Spotify, Apple Podcast, Google Podcast, or directly on our website. And again, to get to our website, go to aglo.psu.edu. And in addition to our other agricultural law resources, the center operates the Pennsylvania Agricultural Mediation Program, which is funded through the USDA. This program is free and has facilitated mediations between ag producers and the USDA, but also different between different parties. Jackie Schweckler, one of our staff attorneys, is our program coordinator, so please feel free to reach out to her with any question you may have about mediation. So the Legal Planning for Specialty Crop Producers webinar educational series has been designed to assist Pennsylvania specialty crop producers successfully expand wholesale sales revenue with income from direct sales, pick-your-own value-added commodity processing or agritourism, agritainment, and educational activities. So over the next 2 slides, I have listed the 6 topics in this legal planning series. The last 5 presentations have already passed, but as I mentioned, you will have access to those recordings. And if you have trouble finding them, please let us know and we will forward them to you directly. So today is our last presentation, and it will be about statutory protections and restrictions for specialty crop producers and understanding Pennsylvania's ag area security, right to farm, ACRE, and clean and green laws. Also, earlier this year, we started a webinar series called Understanding Agricultural Law, which is a course of webinars designed to provide education on fundamental issues of agricultural law. This series is fully sponsored by the Pennsylvania Department of Agriculture's Ag Business Development Center. And on this slide, you can see a list of our future topics. The recordings are available on our YouTube channel if you're interested, but you can also register for our next sessions through the event page of our website. And before I hand it over to Brook, I would like to throw a quick thank you and note that this presentation was created as part of the Pennsylvania Specialty Crop Block Grant Program.
So good morning or afternoon, everybody. Again, this is a series that we have specifically tailored to specialty crop producers. And so it is, in fact, targeted at more of a producer level than what might be a slightly more sophisticated level, which might be for attorneys. I do see that we do have a number of attorneys here, and always good to have that. But I apologize if it's a little underneath your level of understanding. But we want to do this, again, specifically for producers to be able to pick up things. We don't want to shoot too high with the level of the material. So again, this entire legal planning series has been, and I like to sort of concentrate on the little line underneath where it says, understanding understanding liability protections, regulatory processes, and other legal risks. So we talked in the first 5 of these in this series about various liability protections. First one was about liability arising from essentially the farm itself and bringing visitors onto the farm. So related to the maintenance and ownership of the real estate itself. The second one was all about, let's go back for a second, make sure we get these in the right order. Excuse me for a second. There we go. So in liabilities arising from selling specialty crop products, either raw or processed. And so that was sort of a products liability, or what happens when your commodity is in the hands of a consumer who, most of the time we're talking about foodborne illness and who consumes that commodity, but it could be other things. Then the third one was about how to design your business so that you are protected in the maximum way possible from liabilities of various kinds. The fourth one that we did was all about very targeted to selling activity. In other words, licensing and regulatory obligations regarding selling. So it was a lot of governmental requirements and local, state, et cetera, mostly talking about food code issues and how do you get licensed to be selling your commodities for, most of the time we're talking about consumer consumption. And then the last one that we did was all about municipal and zoning. And again, it was designed to try to prevent problems with that kind of land use regulation. So now we're here in the final installment. I think it was worthwhile just sort of going through those so you understand the structure and the sense of all this. The final one is this is kind of like a bonus program in a lot of ways. It tells you about some extra little things that you might want to know about that exist particular to Pennsylvania. And when you are in the game of supplementing your general commodity income, if you were only selling at the wholesale level, for example, with these other income activities and supplemental income activities like value added or agritourism in some way. And these, there's some little tidbits, let's just say, little tips that might be good to know about under Pennsylvania law. And you hear about some of these programs, and now I'll try to explain them to you to the extent that you're not familiar with them. So let me go forward again. Okay, so here are the 4 things that we're going to talk about under Pennsylvania law. We're going to talk about the Agricultural Area Security Law. And that is the law that has led to Pennsylvania's very acclaimed farmland preservation program, where agricultural conservation easements are sold by landowners to generally a combination of government organizations who help fund state, county, and there can even be federal money in there, and there even can be township money in there that purchases an ag conservation easement, which we will talk about. And there are other parts of the ag security law, ag area security law, that also provide you with interesting little benefits that are good to know about. It's not all just about ag conservation easements. Okay, that's number 1. Number 2, we're going to talk about the Right to Farm Act in Pennsylvania, and generally right to farm laws across the country. All 50 states have something like this, and they are somewhat misunderstood, not always understood exactly what they do. So I'll try to clarify that for you. Next, we're going to talk about what's called ACRE, A-C-R-E, Agricultural Communities and Resource Enhancement, I think is what that all stands for. It's just sort of an acronym that was easy to attach to a program, but it's all about, it's a specific to Pennsylvania, very specific, nothing like this really elsewhere. I once heard about a thing that was very similar to this in Australia, but where our Attorney General in Pennsylvania actually has legal authority to review municipal ordinances for the impact that they may be having upon agriculture, and whether that impact may be something that state policy does not want to encourage or wants to make sure does not happen, perhaps is a better way to say it. And so it's about protecting agricultural uses. And there's various aspects of that law, which we'll try to explain so you can get a basic grasp. And then last, we're going to talk about the Clean and Green Law, which is a preferential real estate tax assessment program for agricultural and other undeveloped lands, which gets you a better real estate property tax rate, but also has features of the law which are good to know about, because as we titled this program, it's about statutory protections, but also some restrictions in exchange for getting those protections. So we'll talk about sort of both sides of the coin there. So these four things are what we're going to talk about, try to familiarize you with them. Okay, now we can get going here. The Ag Area Security Law was enacted, and I think it was 80-something, 82 perhaps. I should know that better off the top of my head. And it took many years to get everything with regard to the law up and running, meaning particularly the showcase program of the law, which is the Ag Conservation Easement Purchasing portion. But there are other aspects of that went into a law immediately. And the legislative findings in terms of the policy to conserve and protect and encourage the development and improvement of agricultural lands for the production of food and other agricultural products. So there's number one, declared policy of the Commonwealth. Number two, to conserve and protect agricultural lands as valued natural and ecological resources, which provide needed open spaces for clean air as well as for aesthetic purposes. And also, I think in today's world, we would talk very specifically about water, and not only providing needed open spaces, but also providing, let's just say, the ecological systems for purifying and cleaning our water for reuse has become such a big part. And of course, now we talk about carbon issues also, and the sequestering of carbon in the soil and in other objects or other attributes of our planet that are not the atmosphere, let's just say. Different things come into play as priorities in some of the preservation type actions or efforts that we make in today's world. There's a lot more than open space going on. It's clean water and getting carbon out of the atmosphere. Ag Area Security Law is abbreviated AALS or AASL if you see it. And it does provide certain protections and benefits to the landowners within what's called an agricultural security area. So put aside the agricultural conservation easement issue for a second. The Ag Area Security Law provides for ag security areas. Notice how they transposed those words there in the title of the statute. Probably should have been called the Agricultural Security Area Law. In any event, there's a limitation on local regulation in the law when you're in an ag security area, when your land is in an ag security area, and we'll talk about how those security areas are created. There's also a limitation on the power of eminent domain by entities, government or utility, et cetera, that have the power of eminent domain. And then we'll talk about eligibility for participation in the Ag Conservation Easement Purchase Program. Those three things all arise from having your land in an ag security area, and we'll go over how that happens. Now, the limitation on local regulations is that municipalities are not permitted to enact laws that would unreasonably restrict farm structures or practices on the land within an ASA, an ag security area. Now, this section has been very seldom used legally, but it's in there. And I think in the future, we may see it used more. It's very similar to the general statement of what the ACRE law does, that the Attorney General administers principally. However, this is a very underutilized section. The other limitation on local regulation, if your land is in an ag security area, is that a municipality shall exclude normal farming operations within an ag security area from the definition of a public nuisance. So when you have a nuisance statute that is on the books in a municipality, and people know of the word nuisance as a public offense, so to speak, when you talk about nuisance bars or something. But nuisance can be something where you're emitting a lot of smell, or you're emitting, other types of infringements upon the landowners around you, and a public nuisance is that it's an infringement upon the rights of quiet enjoyment, so to speak, of all of the residents of a township, such that the township has made it an offense to be conducting what's called a public nuisance. So normal farming operations are not to be included in that nuisance. I just noticed that I did not put my camera on. Sorry about that. There it is. Now, also, you just have to know that is modified by the idea that the municipality does have to act or may be permitted to act for the benefit of public health and safety in abating a public nuisance, but normal farming operations are considered to be normal. And if you're doing them in accordance with all applicable laws, regulations, et cetera, then there is no threat to public health and safety. So again, those are some of the benefits of being an ag security area. The limitation on the power of eminent domain basically means that there's a thing called the Agricultural Lands Condemnation Approval Board, or ALCAB, and that entity hears approval petitions to condemn land for a public purpose, roadways, et cetera, utilities, et cetera, that are located in an ag security area. And if your land gets in them, then you are protected by this extra step that the ALCAB board has to have a hearing and approve a condemnation of any of your land within the ag security area if there is, in quotes, no reasonable and prudent alternative. And there are the hearing processes that go on. And when I was at the Department of Ag, I used to provide counsel to the ALCAB board. And it's a branch of the Bureau of Farmland Preservation, where it's administered out of PDA's Bureau of Farmland Preservation. So that's quite a benefit, and does create extra issues with using, condemnation powers for land that is in an ag security area, and can be very beneficial to the landowners. Another benefit, of course, is that this is a prerequisite. This is a required, you must be in an ag security area in order for an ag conservation easement to be purchased by the government from you. In other words, you can sell your development rights subject to a preservation easement, or an ag preservation easement, an ag conservation easement, whatever words you want to use, that simply limits the land to agricultural uses in perpetuity, perpetual, into the future. You get paid now, and it's a good way to monetize your equity. And if you want to make sure that the land you're farming stays in farming in perpetuity, it does limit potentially the market for that land later on down the line. We haven't seen that really as a reality too much in Pennsylvania yet. Now, an acronym for the purchase of agricultural conservation easements is PACE program. So that's why these slides use that acronym. Those are this is all about the programs that purchase. And the farmland owner, as I said, essentially sells the development rights for the parcel of farmland to the state or local government. And there are deed restrictions that then limit the future non-agricultural uses, prevents the conversion of the farmland for development purposes, essentially. PACE programs, here's where they are in the most concentration in the country. These are slides taken from American Farmland Trust a couple of years back, 2020, but they give you the illustration. The lightest green is where there's only local programs. In other words, the state law authorizes local counties or townships or whatever they may have in that state to being the entity that does this exclusively. State programs only are in the lighter green, like in Ohio or Texas or New Mexico, Alabama. Okay, and then state and local programs can essentially be layered on top of each other and be also both in existence and operating at the same time. That's Pennsylvania's situation. Also New York and West Virginia and Virginia, North Carolina, Kentucky, Michigan, Wisconsin, Colorado. And so that's the darkest green. And it gives you some of these numbers here. State and local programs, there's 16 states that have the same type of layered situation. where the light color here is the grayish, tannish color, no active ag conservation easement program in which the government is involved, at least in those states. That's a pretty big swath, is that the right word? In the sort of the Mississippi area and the Mid-South, as they call this, and then the upper Midwest. Okay, here shows you as of 2020, who was leading in the number of acres protected by ag conservation easements, and Colorado and Pennsylvania out there in the lead. This is just a regional. That's why we don't have Colorado over here, but. Maryland also quite a leader here in the East Mid-Atlantic, Atlantic seaboard type area, and gives you, these are old numbers, of course. We are well over 600,000 acres now in Pennsylvania. This shows you the actual number of easements. And, we have particularly a lot because we have smaller farms, but that is some impact, but it's also that our program is much more active. So you can see like the numbers here. And again, this is just for the sort of Atlantic seaboard, mid-Atlantic area here. But clearly in terms of number of easements, Pennsylvania is number one. Okay, this shows you an interesting dynamic, which shows the acres of farmland enrolled. So we start with farmland in the county, and then it's the number that are enrolled in ag conservation easements, in other words, that are subject to those easements where the land cannot be used for anything but ag uses. And this was as of 2017, because I think it's the last time this graphic was ever prepared, but it's as a percentage of the total farmland in the county. So you see Lancaster has a lot of farmland, but also has a lot of easements, but it only comes up at 15.8. Not, I shouldn't say only, that's quite a large number. But you see Berks County comes up much higher. They have a lot of easements, and a slightly smaller probably number of or amount of total acreage in farmland, but probably not much smaller. Very high concentration, much higher than Lancaster and Berks. That's because Lancaster is very developed and has, there are also what's the right word for it? Robust. There are a very robust non-ag development going on in Lancaster too, right alongside with the ag. And you see some of these other counties that are, of their farmland, they have high percentages preserved. Okay, trying to keep going because I'm notorious for taking too much time. Okay, so you create an ag security area by the landowners initiating the process at their local township. And they submit a request to be included in an ag security area, either alone or with other properties. And there is a minimum size limit. There's lots of details and things, but it's a voluntary program where the actual landowners volunteer to be in an ag security area, and then, or at least enough of them within the designated area. And then the hearing process goes on at the municipal level, and then the municipality would change essentially their zoning map to add this ag security area. If it's passed by the local municipality, they have the final say, and then they make their decision. And there are various criteria to be considered. These are some of the more sort of qualitative criteria. There are also size, criteria, et cetera. And I'm going to keep moving. This is a case that if you ever, again, this is probably done for an attorney audience when this case was added into this PowerPoint. I think this was Ross Pfeiffer's slide, but the bottom line is there is some case law sort of addressing what is proper to be included in the ag security area, and it doesn't necessarily have to be current specific ag use as long as it has potential ag use. Now, so that's the ag security area. So, and the ag area security law authorizes the easement purchase program. Okay, fine. But what we wanted to concentrate on is it protects you against eminent domain, at least in terms of there having to be public hearings and this extra administrative step. It also provides various protections against public nuisance. And it has that other language in there that's kind of a little bit unexplored legally so far. But you get some protection from being in an ag security area, bottom line. Next, we will go to the right to farm laws. And what does that actually mean? Okay, right to farm laws exist in all 50 states in some form. What they attempt to do is remedy the sort of conflict between farm and non-farm, neighbors, so to speak. Specifically, we talked about the word nuisance. We're going to talk about that right now. Right to farm laws generally limit, we talked about public nuisances before, where a municipality could enact an ordinance saying that, emanating this smell, or, I had a little experience with dog kennels, and dog kennels make a lot of noise because dogs bark in the middle of the night. So, a nuisance that disturbs, the public generally, well, there's such a thing as private nuisance, which is one landowner wants the neighboring landowner, for example, to stop smelling so much, or stop, certain noise, or, a classic example was the deer cannons, as they call them, where you make this percussive, loud, explosive noise that scares the deer away from nursery growers, for example. And neighbors not happy with that going on at all hours of the night. So there can be private nuisance frictions between neighboring landowners. And that's what the right to farm law is all about. So very clear and very good to understand that that's about private nuisance complaints and suits that might be brought by neighbors. That's generally the focus of all right to farm laws. They're all different from state to state, so you can't really compare them to each other. Enacted in 82, and it was amended in 1998 to add some crucial things about expanding once you're already established in an ag operation. Okay, we're going to skip over that just so that I can get moving here and make sure I finish for the day. The protections granted is it requires the municipality to exclude what's called a normal ag operation from the definition of a public nuisance. And so that's a repeat essentially of the ASA, the ag security area, but it also limits private nuisance actions against ag operations. And it also limits the ability of municipalities to restrict direct commercial sales of ag products, which is an important one for specialty crop growers. Now, the definition of a normal ag operation is very crucial in Pennsylvania law, because that is not only the definition under this law, the Right to Farm Act, that is to provide benefits to normal ag operations, particularly against nuisance suits. But this definition of normal ag operation has kind of become the de facto definition, or the default definition, of what is a farm under Pennsylvania law. And this is used in other laws, which we will see in a minute. It's used in the ACRE law also. But it becomes sort of, what's a farm under Pennsylvania law? Well, this is one standard or one threshold that has been used in a number of Pennsylvania laws, started with the right to farm law. And essentially it's, the activities, practices, et cetera, utilized in production, harvesting, and preparation for market of, and then, various commodity products for operations that are at least 10 acres in size or produce an annual income of at least $10,000. Or produce an annual income of $10,000. Now, the key thing that's missing here is retail sales. As you see, under this particular act, Right to Farm Act does not recognize retail sales as a normal ag operation. Interestingly, in Pennsylvania's ag area security law, agricultural production in the definition does include retail sales. So when you have a preserved farm, you have certain rights that, to retail sales there, as part of the agricultural operation. This law does not recognize that. And that's a continuing issue in Pennsylvania law, where farmers get certain protections, but does that include retail sales? And that's really, there's so many instances where that is a big issue. And we'll go on, talk about that a little bit. Okay, now, these are the types of agricultural operations that get the limitation on nuisance actions. In other words, nuisance actions can't be brought against you if you are in operation lawfully for at least 1 year, and the operation is, it's in a small o. In other words, it means the certain thing that you're doing that is, we'll just say, aggravating your neighbor, must have been in operation for at least a year. conditions complained of have existed since the established date of the operation, which is what I'm getting across there. And then the conditions complained are from a normal ag operation. So it's like a 1 year, you basically get sort of a 1 year ability to do this thing. And if nobody has complained by way of a nuisance action within a year, then they essentially are not able to complain after you've established it for that year. Let's just put it that way. So that's what the right to farm law is all about. People get very confused about what it means. And now, if you have established your ag operation, then you expand it and you alter it in some way, like you just got a lot bigger, you're doing the same thing except on a larger scale, perhaps, then it's kind of a similar thing, which is, okay, you expanded or altered it at least a year ago, and or I should say, or some, and this is where it comes up a lot of times is, let's say you have a swine, you're doing some amount of raising of swine, and you have your nutrient issues, and you need to manage those nutrients depending on whether you're a CAFO or you're smaller than that, or whatever the situation may be. But expansions and alterations, as long as you're dealing with them in a nutrient management plan that is appropriate and compliant with Pennsylvania's Nutrient Management Act, then you are also given essentially a defense against private nuisance actions, because you're doing what the state has told you to do, and they've already spoken on handling of nutrients from those animals, and you're complying with it. Okay, direct commercial sales must be permitted on a normal or on the site of a normal agricultural operation. In other words, local municipalities, this is a very good protection, a very important one, may not be prohibiting direct commercial sales if the property is owned and operated by the landowner who produces at least 50% of the agricultural commodities sold. So it's got to be on the land of the person who produces at least 50% of what's being sold there. And that's separate than the nuisance protections. This is a standalone protection in the Right to Farm Act that's all about protecting the ability to engage in direct commercial sales and direct retail sales on site. So there's a very important protection for specialty crop growers. There are exceptions to the Right to Farm Act under Pennsylvania for different things, like, again, an adverse effect on public health or safety. Zoning ordinance actually prohibits or limits this operation in some way legally, and we'll get to that in a second, because the ACRE law can still look at that, and or you're otherwise not essentially complying with various provisions of law. In other words, you're not fully compliant with the laws that apply to you. I'm going to skip over. There's a case that sometimes illustrates some things, but I want to make sure I get done and even have time for a question or two. Okay, right to farm laws sometimes have constitutional challenges to their ability to essentially take away the right of neighbors to file a nuisance action. There's sort of a division between limited prohibition on nuisance actions, which is what Pennsylvania's is, versus an absolute prohibition, which is on nuisance actions from neighbors, which is generally been considered to be an unconstitutional taking of their ability to bring that action. However, the limited prohibition, and what I mean by that is that there still are those exceptions for things that might not be compliant with the law or are somehow a public health and safety issue. And so Pennsylvania's law has been constitutionally clear for quite some time, and there aren't any question marks legally as far as that goes. We will go to our last two. So, we talked about the ag area security law and ag security areas and what that gives you protection-wise. Then we talked about the Right to Farm Act and what that provides to you. Now let's talk about this ACRE law, and then we'll talk about clean and green. And clean and green provides you something, but it also limits you, and that's the part that we really want to talk about. Okay, the ACRE law has several parts. This is OAG, means Office of Attorney General. So under the ACRE law, the Office of Attorney General, which for those who may not be familiar, the Attorney General is an independently elected office, not within the governor's jurisdiction, so to speak. And this is the position that the future governor of Pennsylvania just held. So the idea being that the Attorney General is neither aligned with the governor nor aligned with any with the legislature in any way. It's an independently elected office that is answerable to the voters of Pennsylvania. And the idea that they would review and what they do is they review municipal ordinances for what is going to be considered by Pennsylvania law to be an unreasonable restriction of ag operations using that normal ag operation definition again. And it's really an intensive sort of program where zoning ordinances are reviewed by the Attorney General's office upon complaint to the Attorney General's office, and any landowner can lodge those complaints, so to speak. And then there are some preemption issues in there, which what that means is essentially, are there things that the local municipality did that have already been addressed in law, and they're not allowed to then duplicatively try to create requirements for those things, like nutrient management responsibilities. And that's one area where we basically have a fairly solid preemption. How it came to be is more for the lawyers to unravel. But the bottom line is we basically have a preemption of local regulation of nutrient management issues because of Pennsylvania's Nutrient Management Act. And that's what the word for that is. It's called, it preempts local regulation, the Nutrient Management Act. And that actually arises, its most solid affirmation of that is this Berner versus Montour Township case, which was only a couple of years ago from the U.S. Supreme Court. And then we'll talk about the Clean and Green law. So let me just keep moving. Okay, this is a little description of 2005 is when the ACRE law was passed. Or actually, I think it passed in, maybe it was, no, I think it did pass in 05, not 04. Sometimes it is called Act 38. And it's, again, to ensure that ordinances adopted by local governments to regulate normal agricultural operations are not in violation of this particular state law. And this state law says that a local ordinance cannot exceed, duplicate, or conflict with state law on a particular topic. An unauthorized local ordinance is an ordinance enacted or enforced by a local government unit which does either of the following: prohibits or limits a normal ag operation, unless the local government unit has some type of independent authority to get into that field and regulate that, and it's not prohibited or preempted, as I sort of described for you with nutrient management issues, or it restricts or limits the ownership structure of a normal ag operation. That's an interesting one, because it was designed to deal with this idea of a local ordinance that said no corporate farms, and this law basically says Pennsylvania's state policy is going to be that you can't judge a farm by its ownership structure. Let's just say, just because a corporation may have been created to own a farm doesn't mean that it's something that we are going to allow local townships to prohibit in their township. So now there's also ownership structure issues with regard to potentially foreign investors investing in farmland. That's a different thing, and it's somewhat unexplored. We'll get to that in a second. It's sort of unexplored whether this law would apply to that. It's becoming somewhat of a hot button issue these days. Okay, so this was enacted because the Right to Farm Act, while it provides some protections, particularly against the private nuisance actions, and we already heard about the ag security area providing those protections against public nuisance ordinances enacted by townships. That was really only for nuisance claims, and that's a limited number of things that a farmer is going to run into. More likely, they're going to run into, other problems that aren't being asserted as nuisance claims, but are prohibiting them from doing, the activities of their normal ag operation. So this Right to Farm Act was just a defense to nuisance claims, and that was inadequate. And people recognized that that was inadequate. It also required essentially the farmer to pay all the costs of having to defend against these suits. Even if they would win based upon the Right to Farm Act, they still ended up incurring all kinds of attorney's fees. And there was no way to use it until you got sued. So it didn't have a lot of usefulness in terms of, you know, saving the farmer from getting embroiled in something ugly. This law came into being and says, okay, now we're going to give a farmer something that is a bit more of an offensive way to use a protection granted to a farm. It's more of a sword, not just a shield, so to speak. So it applies to all forms of local regulation of normal ag operations. And it essentially says, I may jump ahead here and then come back to this slide. Let me go ahead. It says that, as I sort of explained to you in that one little slide that had the photo of the silo on the right-hand side, that local governments shall not adopt nor enforce an unauthorized local ordinance. So then the big question is, what's an unauthorized local ordinance? And we'll get to that in a second. And again, one of the other premises of the ACRE law is that not only does it apply when the municipality is actively engaged with a landowner in some type of dispute over their ag operation, but it also can be applied even if you read the ordinance and just on its face, just reading the ordinance you can see that it's going to infringe upon something that is a normal ag operation, or that it's going to duplicatively try to regulate something that the state has already regulated. And so it applies to local regulation as written or as applied. In other words, how they're enforcing it directly against you. Hopefully that makes some degree of sense. Just in terms of the context, this was enacted at the same time when odor management, the odor management for CAFO's statute was, Odor Management Act was enacted, as well as there's odor management regulations. And so that gives you a little bit of the context. This was when, you know, the idea of friction over smell was, you know, a very, very large issue. It probably still is, you know, particularly obviously from swine operations and, you know, poultry operations too. But we all know the story. You know, people come out from an urban area and want to be out in the country. And then once they get out in the country, they don't like how it smells. And, you know, we've lived through decades of that. Okay, now, key definitions, as I said, were unauthorized local ordinance. What exactly is an unauthorized local ordinance? And then normal ag operation, you have to be operating one. Well, we already talked about that a little bit. And remember, it doesn't include retail sales. It has to be at least 10 acres or producing $10,000 of income. And okay, now, what's an unauthorized local ordinance? Any ordinance enacted by a government unit that prohibits or limits a normal ag operation unless the local government has the authority under state law to do it. In other words, they're not duplicatively stepping in somewhere where they shouldn't be because the state's already regulated that, like nutrient management issues, or local government and they're not prohibited or preempted, which the Nutrient Management Act actually has preemption language. So that sort of just sets you up. Okay, that's now the key in this whole thing is prohibits, okay, limits a normal ag operation. What exactly does that mean? And that's still a term that's sort of in flux and has, you know, different meanings as applied to facts that get presented to the Attorney General's office in particular. So that is where the meat is, so to speak, in the ACRE law, is defining when is something an unauthorized local ordinance because it's somehow unreasonably limiting a normal ag operation. And that's a continuing question. That's sort of what you'd call a subjective determination that the Attorney General is being given to perform that function. That's their job. Okay, now, this idea about the ownership structure, let's talk about that for 1 second. It also has these provisions about ownership structure. And again, this is probably more a curiosity, just more than a practical thing for you to know, that it has this, the definition of an authorized local ordinance also includes any ordinance that restricts or limits the ownership structure of a normal agri operation. Okay, so-called corporate farms is what this is all about. And this idea that a township shouldn't be able to just blanketly say, based upon it's a corporation. Oh, and then you're not allowed to operate a farm that's owned by a corporation. Well, it could be a family corporation of spouses or children or whatever. But also foreign or out-of-state ownership. That's a really unanswered question as to whether this applies. We have laws that could be applied to the foreign ownership of farmland in Pennsylvania. We don't have them recently enacted. We have old ones on the books, some of which go all the way back to the Civil War, when you had part of the country who left the country, and then when they came back, the legislature in Pennsylvania in the 1860s didn't want them coming up here and buying farmland or buying any land for that matter. Some of this goes all the way back on the Pennsylvania's law books anyway, goes back that far. The bottom line is new movement in the country about fears and concerns, and particularly on the federal level, it's starting to really ramp up. There are lots of things on the books already, or there are laws on the books already, federally and in many, many states. But how this is going to play out with regard to foreign ownership of particularly farmland in Pennsylvania, we will have to see. It has not bubbled to the surface here like it has in some other states, and sort of slightly on the national scene at this point. And whether this would apply, we don't know. We'll have to see how that develops legally. But okay, so the normal ag operation, again, we went over the definition of it. And again, I always just like to point out that, of course, it doesn't include retail sales, which is an important thing to understand, because people think that their ability to have a farm market on their premises is legally protected. It is to a degree, and particularly if you're in an ASA, but an ag security area, but it's not for the purposes of the ACRE statute or the right to farm law. So in either of those, if your retail activities are being infringed upon by nuisance suits or actions of the township, that's not necessarily automatically within the protections. And generally it isn't within the protections. You got to comply with all of the normal requirements with regard to your retail operation. That's kind of what we talked about the very last session we did. Okay, now the procedure is that a producer, landowner, submits a written request to the Attorney General's office for review. The Attorney General has 120 days to determine whether they're going to accept and pursue the case. Now, if they accept it, they give the municipality a chance to negotiate and maybe even settle, to revise their ordinance, usually is what it comes down to, or revise, how they enforce an ordinance. But if it doesn't settle in some way, the Attorney General can file a lawsuit at the Commonwealth Court, and that is essentially an act of the government picking up the burden and expense of defending the farmer's right to continue to do what they're doing in the face of some type of local municipal interference. And so it solved the problem of the farmer being the one who had to finance all of their own legal fees, and you had to sit back, as was the case with the right to farm law, and even wait till you get sued to assert it as a defense. Here it can be used offensively. It can be used by the Attorney General to step in and assist a landowner when applicable. Now, and that's kind of what I said here, costs are borne by the Attorney General. There's also a private right of action. An individual person can sue under the ACRE law too. That's very underutilized in Pennsylvania right now, but it does exist. And there's even a right to get attorney's fees from the other side if you win. And there's sort of a high bar for that. If you are the landowner saying that the municipality has infringed upon your rights to operate your normal ag operation, there has to be proven a negligent disregard of those rights by the township. And in the other way, if somebody sues a township and it's determined that it was frivolous or without substantial justification, then that can go the other way. And the party who sued the township under the ACRE law can owe the township attorney's fees. So it can go both ways. And it's all litigated in the Commonwealth Court, which then sets this statewide precedent. So it's not just individual county courts that then other counties can say, well, that's a different county, we're going to roll differently here. So that's very helpful to do it that way. There are annual reports that the Attorney General's office issues. This is the 2020 annual report here. Usually it's a little difficult to get your hands on those sometimes because they only get released to the legislature. Then you have to sort of get them after that, and there's not a set schedule. But they do exist, and if you contact me, I can get you the current ones. I have the 2021 now. Okay, now, and this is the website for the Attorney General's office for the ACRE program. And so that's why I got the slide in here. This is the little flyer that they did. And that's the link for and they actually have a very nice website, which I'm gonna go for. This is a little brochure they did. Here's what their website has, which is really interesting. Their website has a table, and it goes on for pages and pages, of all of the complaints that they've received about particular townships and maybe what the issue was, and then what they have done in response to them. And so you can look at these and see what the Attorney General's office has said about certain things that townships have attempted to potentially, or it's been alleged that they have infringed upon a landowner's right to what the landowner feels is a normal ag operation. And you see some of the issues here. Oh, dog kennels, there you go. Timber harvesting. There can be a lot of issues there with regard to a township's infringement upon timbering and the harvesting of forest products. That's a very unsettled area right now. So because forest products, silviculture, that is all within normal ag operation. So this is a great chart that they have on their website. Okay, I'm gonna keep going because I am, running time tight here. Now, I'll tell you what, I am going to skip this next couple slides. These slides are all about what's called the Municipalities Planning Code and how it butts up against ACRE. The Municipalities Planning Code is the authority that townships operate under in order to even have zoning. And then there are some key provisions that kind of work, together with the ACRE law in that area. But I'm just going to proceed ahead because I have a very important clean and green discussion to get to here. Okay, now, Clean and Green. This is the program whereby you enroll your land and get a better a property tax bill. In other words, a reduced property tax bill, a preferential tax assessment for agricultural uses and other uses that are undeveloped. In other words, not developing your land. There's a forestry, and I will get to that in a second. And there's also what's called ag reserve, which is maybe not actively being farmed at this moment. Now, here's the name of the law. It's not called Clean and Green on the law book, so you can't find it. That's why, because it's actually got a longer name, the Pennsylvania Farmland and Forest Land Assessments Act. And there's big regulations. These are all links. The regulations are very extensive and very key to this. There's a lot of them. They get tweaked a lot. Now 59 of the 67 counties have this program. So not every county has the preferential tax assessment program or a preferential tax assessment program. I see Chloe has joined us by video. Let me just go through this section and then we will get to our questions. We might want a minute or two after. Let's get our programming in and our questions will be bonus. Okay, Clean and Green goes all the way back to 1974 and it values the land based upon how it's being used, the value as used, meaning not developed, versus its highest and best use, which is the way property tax generally works. that your land is valued on the prevailing market value for the highest and best use. So you throw that out and you use its highest and best agricultural use, which is much lower. And there is, this is a pretty eye-opening statistic. The average reduction in property taxes in the fair market assessed value for people enrolled in Clean and Green is roughly 50%. Now, it can depend on your county and what your county tax rates are and how land values are in your county and all of that. But this is an average that at one time in the 2020 Farmland Preservation Annual Report on the program, that was the estimate. Pretty impressive. Okay, here's the three categories of Clean and Green you can enroll as agricultural use, actively being farmed, agricultural reserve, which is essentially open space, not necessarily having to be farmed. That's sort of the most controversial area. I'll set that aside. And then there's forest reserve, which is essentially land capable of yielding various forestry and timber products. And there is a big issue in Clean and Green that you have to understand, which is rollback taxes if you change the use. So here's where it gives you certain protections. You get a better tax rate is the protection, but it also has restrictions. And the restrictions are for the use that you've enrolled it. If you change it to some use, in other words, you've changed what you're doing on any portion of the enrolled land, you may end up owing back taxes, and your back taxes that you owe, the rollback tax is the word for it, is the last 7 years worth of tax savings that you realized by being in the program. So if you got a $10,000 tax reduction by being in the program, and you change the use in some way, or change the use of any part of it, depending on the circumstances, then you're going to owe $70,000, of back taxes because you violated what's the terms of the program. So that is the best, probably succinct way to summarize everything. Now, retail sales are allowed as rural enterprises in the ag use category. So remember, we've been talking about retail sales and where they're permitted and where they're not. In Clean and Green, you can have retail sales on site, and there are some conditions. And I just want to show you, that shows who's participating. This is the slide. Now, what it says essentially is that a maximum of 2 acres of land that is enrolled in the program can be used for direct commercial sales of agriculture-related products or activities, meaning other types of agritainment, agritourism, et cetera, if it's sufficiently related to your agricultural products. And they call it a rural enterprise incidental to the operational unit, meaning that it's a rural enterprise incidental to your main thing you're doing there, which is farming. And the retail, we'll just use farm market for our illustration. The farm market is owned and operated by the landowner. And that's kind of similar to what we talked about before. The inventory of goods verifies that they were from the landowner themselves, and that it does not permanently render the land incapable of producing an agricultural commodity. Okay, so you haven't paved over, large swath of your land there. And then there are some conditions. The rural enterprise is supposed to take up not more than 1/2 an acre. So that's a pretty small farm market, depending on your circumstances. 50% of the products are produced on that site, and that didn't require any new utilities or building. I just had a go around with a landowner that's getting socked on this third requirement because he did put up a little shed there. So just know that under the Clean and Green program, you can engage in retail sales on site without suffering a rollback, but there are some conditions you have to satisfy. All right. This is all about other exceptions to when you're in the Clean and Green program, things you can do that are sort of outside your main use. And so here we go. Here's a summary of what we did today. We talked about these 4 laws. Hopefully you have a better understanding of those. Chloe, what do we got for questions?
So we got two questions, Brooke. So first, does Pennsylvania have home occupation business, for example, piano teacher? If so, could there be retail sales under that?
Okay, so that, since the piano, well, I'll put it this way. If it's a home occupation business that is connected to agriculture, then you sort of get into, does it fit within the definition of normal ag operation for, right to farm, an acre, or in the clean and green? Does it fit within this, rural enterprise language, that sort of thing? Now, general zoning, yes, allows home occupations that might be or can allow, like music lessons, let's say. But that would be strictly a zoning issue. So unless this home occupation is a agriculturally related home occupation, this question is simply a general zoning question. Yes, your zoning ordinance might allow that, but you have to look into it. And giving music lessons doesn't gain you any of these protections, even if it goes on the farm, because it's not agriculturally related. And that would apply also with the retail sales portion of that, selling sheet music or something like that. None of that would get the protections of any of the things we talked about here, because it's not an agriculturally related business. Okay.
So the second and last question, the USDA National Ag Statistics Service, I think, says that Pennsylvania ranks second in nation, only after California, for direct farm sales in dollars. We used to be first in number of sales direct from farm. So if direct sales are so prevalent, why isn't this protected by law?
Oh, Phyllis, you have asked the $64,000 question. And in fact, you see, I've tried to get that across to you, that some of these laws do provide for it, but then other places, it's not quite so clearly discussed, or clearly addressed. And so, for example, in the ag conservation easement program, it's very well addressed and very accepted that, all of these things are going to be allowed. Direct sales, I should say, there's not really a whole lot of controversy over that one. Now, there might be some issues about, the requirements of the township in what they're requiring you to do in terms of a building or whatever. But and then you see, I tried to go through, as your question asks, some of the, variability between these other programs. You have some of these ideas that are very consistent, like, at least 50% of what you sell have to be produced by this landowner, or at least on this site. But you're right, there's variability, and this is an area that definitely could need work. And then she asks, is there a lack of political will to protect small farms' direct sales? That's a good question. I think the legislature in Pennsylvania probably has never been presented with, in a real clear sort of way, that, hey, you're providing protections for a farm market, an on-site, on-farm retail sales, but you're not doing it in a consistent way that is understandable by the public, and by the landowners, and even by the municipalities, who are, sort of the ones who are the frontline, potential regulators of that activity. So I think it's not been presented. I think they're probably, my guess, personal opinion, I think political will might be there to clean this area up a little bit and create a little more consistency. I just don't think it's come to the forefront yet. I don't think that the legislature really appreciates the variability between these different laws, and maybe we should straighten this out. Because the legislature has done some real nice things in terms of that definition of normal ag operation is really a broad definition and is very inclusive. And that definition has been used in a number of different contexts, not just in the ACRE law after right to farm, but it's also been used in the most recent immunity statute for agritourism and agritainment activities. That also starts with the concept that to get this immunity, you have to meet the definition of normal ag operation. Now, the problem that we still have, as Phyllis has pointed out, is that the normal ag operation definition doesn't include retail sales. But at least the legislature has recognized the importance of having consistency in some of these definitions, because they're using the same one so that everyone will have some practice with using the definition, and it becomes a standard. Now we have to maybe try, if there's the push to standardize direct sales and the treatment of direct sales from on the farm. So I think that's about as good an answer. And that's an excellent question. Thank you, Phyllis, for raising that and bringing that up, because you hit it right on the head. That's the heart of it. So, all right, we are at 1:06, so we went a couple minutes over, but I hope people thought it was worth it. Thanks everybody for attending this series, all 6 of them, if you've seen them all. We are now going to proceed ahead, and we're going to put together essentially a booklet that accompanies this series. And that booklet is going to be distributed to everybody who registered for the series. At least if you registered for one of these, then you registered for the whole series. You probably know that because you get the emails. And now we're going to provide you with the booklet that goes along with this, that is sort of besides the video and the PowerPoints, which you can always look at on our website, you'll get this booklet. We will attempt to put that together in the coming months. Our exact timeline for that is not clear yet in terms of when it's going to be the first few months of this fall of the 2023. So for everybody who has attended, thank you so much. And you will continue to be hearing from us. We're going to have some surveys going out to you to see how this helped you. And that'll all help us plan in the future to, again, provide hopefully services directly for specialty crop growers, because as the question that Phyllis Rubin sent to us here, Pennsylvania has this expertise and this, status in direct farm sales that we want to continue to grow and encourage for the benefit of everybody. So having said that, good afternoon, everyone. Have a good day.